The plaintiff allegedly was injured in a motor vehicle accident on May 12, 2000 in Nassau County. At the time of the accident, her motor vehicle was insured by the petitioner, American Manufacturers Mutual Insurance Company. She had also purchased supplementary underinsured motorists coverage. The offending vehicle was insured at the time of the accident by American Insurance Company. On February 5, 2001, American agents were placed in liquidation. On May 25, 2001, Morgan filed a demand for arbitration claiming that the offending vehicle was uninsured. American Manufacturers filed a petition inter alia to permanently stay arbitration under its coverage on the ground that American agency was a domestic insurer required to pay into the Public Motor Vehicle Security Fund pursuant to the insurance law. American Manufacturers argued that since Morgan could seek compensation from the security fund, the offending vehicle was not underinsured, and Morgan's resort to the arbitration clause of her insurance policy was precluded. Morgan countered that the applicable endorsement to her policy contained the same definition of uninsured motor vehicle as Regulation 35D, i.e., where the insurer is or becomes insolvent. Thus, Morgan argued that whether by dint of regulation or American Manufacturers' own contractual agreement, the offending vehicle fell squarely within the definition of an uninsured motor vehicle, and the position to stay uninsured motorist arbitration should be denied. The Supreme Court denied the petition, and we affirm, but for different reasons than those stated by the Supreme Court. The Supreme Court's holding, based in part on the clear and unambiguous language definition of an uninsured motor vehicle as contained in Morgan's endorsement, though correct, too narrowly determines the issue presented. The sole controversy presented in the action at bar concerns the definition of uninsured motor vehicle as used in Regulation 35D, entitled Requirements for Endorsements. Regulation 35D was promulgated by the Superintendent of Insurance effective as of October 1, 1993, under the authority of the insurance law. The regulation defines an uninsured motor vehicle insofar as is relevant here as a motor vehicle for which there is a bodily injury coverage or bond application at the time of the accident, but the insurer writing such insurance coverage or bond becomes insolvent. Contrary to the arguments of American Manufacturers, the determination in this proceeding is not governed by the Court of Appeals holding in Statewide Insurance Company versus Curry, a case decided prior to the enactment of Regulation 35D. There, the court held that the subsequent insolvency of a domestic insurer of an offending vehicle does not render that vehicle uninsured within the meaning of the New York Automobile Accident Indemnification Endorsement, the compulsory uninsured motorist endorsement. See Statewide Insurance Company versus Curry Supra. The basis for the holding is what distinguishes it from the proceeding at bar. 1. The offending vehicle did not fall within the definition of an uninsured motor vehicle as defined in the compulsory uninsured motorist scheme, that is, where the insurer disclaims liability or denies coverage. Since an offending vehicle whose insurer becomes insolvent could not be classified as uninsured under the definition set forth in the relevant statute, and the injured motorist could look for compensation to the security fund, the protection afforded by the compulsory uninsured motorist scheme was held to be inapplicable. The court's holding in Curry was expressly limited to the insolvency of domestic insurance and insurers, since non-domestic insurers do not contribute to the Motor Vehicle Liability Security Fund. The Supreme Court, Nassau County, applied the holding of Curry to the only reported post-Regulation 35D case, which is factually identical to the proceeding at bar. The error in the holding in matter of government exemption insurance company versus Supra is that it interpreted Regulation 35D, and in particular the definition of an uninsured motor vehicle, so that it was consistent with the Court of Appeals interpretation of an uninsured motor vehicle as set forth in the compulsory uninsured motorist scheme. Regulation 35D is intentionally broader than the compulsory uninsured motorist statute, and its very purpose is to provide those who exercise the option to purchase this additional insurance with broader coverage. In response to public comment to Regulation 35D regarding any conflict with the holding in statewide insurance company versus Curry Supra, the Superintendent of Insurance responded in pertinent part, while the court's rationale is a reasonable one with respect to the compulsory uninsured motorists coverage, supplementary uninsured motorists coverage is an optional additional coverage. The individual insured for supplementary uninsured motorists coverage should not be required to wait for a recovery from the security fund on behalf of the insolvent insurer.
How do you write insolvent?
3 strokes.
Yeah.
That was it.